You're watching The Property Cast, powered by the award-winning Total Landlord Insurance.
And welcome to the latest episode of The Property Cast. My name's Eddie Hooker. I am the Chief Executive Officer and founder of HFIS. And as always, I'm joined by Paul Champlina, founder of Landlord Action, and my Chief Commercial Officer. Welcome, Paul.
Edward.
And delighted, as always, to invite a special guest. And today we've got Paul Sowerbutts, Head of Legal at Landlord Action. Hello, Paul. How are you?
Hi, Ed. Hi, Paul. Yeah, I'm fine. As Ed said, I'm Head of Legal at Landlord Action and looking to get stuck into my first property cast.
Your first property cast. And actually, we're going to talk today, we're going to dive a little bit more deeper into the Renters Reform Bill, specifically about the changes to evictions with the removal or the proposed removal of Section 21 eviction or accelerated procedure to get your property back at the end of the tenancy.
You're watching The Property Cast, powered by the award-winning Total Landlord Insurance.
Let's just drive straight into this because it's quite a deep conversation and it is causing quite a lot of concern and worry in the landlord community. And there's a lot of commentators talking about the impact of Section 21 when it goes. But before we go there, I just want to dive in. For the new landlords that may well be watching and listening to this podcast, Paul, what is Section 21? And we all talk about Section 21. What is actually the Section 21?
Well, the Section 21 effectively is no fault, no reason way of evicting a tenant. It was introduced back in the late 80s and as an alternative route to having a reason for evicting a tenant, Section 21 enabled a landlord to get the property back for no reason.
So it's literally a clause in the legislation.
But there normally is always a reason.
Called
Section 21 of the Housing Act 1988. As Paul says, there is normally a reason behind it, but the legislation doesn't require you to say what that reason is. And the point is that you can go to court and the judge effectively has no choice but to give you that possession order.
Okay, and in practice, Paul, how does it work?
Okay,
give us a potted, very quick, because I know it's quite more complicated.
Well, the point is that for years and years and years, it worked really well. And you just serve the notice, and but then came along the Deregulation Act 2015, and since the 1st of October that year, essentially there have been hurdles, number of hurdles to get over, gas safety checks, all good, sensible things to have in place, but essentially they've been tied in with the Section 21. So whereas the Section 21 went along nicely and you could evict a tenant, and there were lots of legislation about regularising the tenancy, making sure the conditions were in good order. These were then tied in with Section 21, right. And so therefore it created these hurdles. And so it always used to be the case, well, there isn't really a defence to Section 21 other than technical matters, and those technical matters have become so bogged down, they're almost like a substantive defence now. Things like gas safety check, things like property deposit protection.
Right. Okay. So in effect, the landlord wants to get his property back or get her property back. They fill out a form, and now they have to provide evidence that the deposit was correctly protected, that it has an energy proficiency certificate, and it has gas safety, and it has other things.
And licensing, HMO
and then everything gets served on the tenant, and the tenant then says, thank you very much, I'm leaving on the X date. And then if they don't, you push it through to court. That's effectively how it works?
Yes, I mean, in fact, the notice itself is actually quite straightforward. But if they don't leave, then the N5B, the court form, and then you attach all that evidence, send it to the court.
And at Landlord Action, Paul, what sort of problems do you see in terms of Section 21 as it currently stands?
As it currently is, yes. As it currently is, and has been for a number of years now. There are problems all the way along, but the main ones that we find that are coming up again and again are gas safety certificates.
People don't have them.
They don't have them, and they do and they haven't served them.
But I think also another issue is that which is a real bane of a landlord's life, is they can't get access from tenants, which is an issue as well.
Absolutely.
Isn't it?
You not only can you, even if you have got one and you've not served it, you can get around that. But if you can't even get into the property to get your gas safety check done, that can be a problem. Yeah. There is a very, very specific point where about tenants, so this is something really important to remember if you're just starting out, is that gas safety check before the tenant moves into the property, because that is unremediable. If you don't have one of those, then you're in trouble. But broadly speaking, gas safety check, once you've got in, once you've got the certificate, you then serve it and you get round it. But it's just more paperwork.
And what happens, Paul? So I want to get my property back, and I serve a Section 21 notice to the tenant, and the tenant says, you haven't protected my deposit correctly, you haven't given me a gas safety certificate, you haven't done X, you haven't done Y. What then happens? Where's the risk to the landlord?
Okay, well, I mean, if the tenant wants to go, once you've served the notice, then that's fine. But if they don't, and let's say the local authority, they want to go to the local authority is saying you've got to remain there until the end, if you like, the tenant then can raise these points in a defence. Yeah. And then the court will have to grant a hearing. So ordinarily speaking, the accelerated procedure would be followed using a Section 21. If a tenant then puts in a defence to say, look, there's a problem with the gas safety, there's a problem with the deposit, then the judge has to set a hearing date.
On that point you just said, and I think it's a real common, and I think we should air it, because it's an issue for landlords, and you mentioned it, and I see it all the time, I've been seeing it for years, is that the councils are still telling tenants to stay put until eviction. Yeah. Because if they leave the property, they're going to voluntarily make themselves
homeless, and then the council will have to pick up on it.
Because we have a big social housing crisis, that burden gets put back on the landlord.
Once you've got that hearing, then the tenant's going to provide the evidence. Even when you've got the order, you've then still got to wait for the bailiffs to come round. So it's a long period that the local authority is requiring you to sort of carry the case.
And of course, the impact here is that generally, in a lot of cases, the landlord wants their property back because the tenant is not paying rent.
And they're going under Section 21 instead of Section 8.
Absolutely. So, of course, what then happens is that, yes, the timescales get longer and longer if you haven't done everything that you need to do, and every month goes by, you're not getting the rent coming in the door, and that is probably why this is quite a big topic at the moment.
Yeah, I mean, I think the point about even if they were paying the rent, often once they get the notice, then they do stop paying rent. Tenants often do stop paying rent, but the periods of time. I mean, to give credit to the HMCTS, they have brought down the gap between issuing and getting a court hearing, so that has improved. But the big topic at the moment in the last few weeks or so has been the point at which you've got your order and the bailiff coming round. The bailiffs, there's a sort of bailiff freeze, for want of a better phrase, whereby they're not able to go around, they haven't got the right PPE, and this is just a further delay.
We've got one landlord. There's an 80% reduction of bailiffs in the London courts. And they won't transfer cases up to the High Court. This is a big issue because it basically speeds up eviction, and of course and this is quite deep, a bit more political, but of course we have a temporary accommodation crisis, we have a social housing accommodation crisis. We have one landlord that's waiting 7.5 months for an eviction date in London, and he's not getting his rent.
And he's not getting his rent.
Yeah.
Do we have any statistics on how many Section 21 notices are issued in the UK and how many are actually then referred up to? In other words, the tenant doesn't accept that Section 21 and then it gets delayed. Do we have any numbers?
Look, no one knows how many Section 21 notices are served. I don't know how many have served in letting agents. What we do know is accelerated possession applications, give or take, there was about 20,000 last year. That will increase in 2023. The most we've ever had, believe it or not, was in 2003, I believe, or 2005. We had 35,000, and the accelerated possession procedure came in 1999. So if you think about, and I know we're going to talk about when it's going to be abolished, when it's abolished Section 21, there's no more accelerated proceedings. But I can tell you now, from speaking to a judge, and a lot of landlords wouldn't know this, a judge will spend the best part of 15, 20 minutes looking at all the paperwork before granting possession order. It used to be in the old days 90 seconds. There's so much to look through.
Yeah, of course.
And there's so many more defences. And of course, we haven't even talked about retaliation eviction, which maybe you want to explain. What is retaliation eviction?
Retaliatory eviction effectively is where the definition of a tenant complains, for example, about some sort of disrepair, and then the landlord then decides to say, well, I'm not going to fix the property. This is the
and I don't want you moaning. Off you go.
I'm going to serve you a Section 21. I don't have to give you a reason for doing it.
Yeah.
But
and is that common, Paul?
Well, because we don't know exactly. From my experience, landlords are not doing that. They're not reacting in that way. They're wanting to evict for other reasons.
Yeah, I think relating to that, because I did quite a lot of research and I've written loads of press about retaliation eviction. It's a tiny amount. It's a really tiny amount. I think now, with regard to what's happening now with tenants, because of the rental stock crisis, and we are in a massive crisis now at the moment. There is an argument to say that some tenants are fearful about reporting disrepairs, because actually there's so many landlords that are serving Section 21 at this moment in time because they want to exit the market. Yeah. So there is that worry.
So you don't know. I think that's the point.
You don't know because you've never had to give a reason, and it's called non-fault, but there's always a fault. Obviously, sometimes the tenants.
Because most landlords, to be fair, if they've got a good tenant paying their rent, they get on with them very well. It's a home.
You want to keep them.
It's a family. You want to keep them.
You're watching The Property Cast, powered by the award-winning Total Landlord Insurance.
What's the difference between Section 21 and then the other common terminology we all hear, Section 8?
Section 8, yeah. Well, Section 8 is for a reason. That you have to give in your notice, and if it goes to court, the tenant doesn't leave, you have to give a reason for wanting the property back.
Yeah.
I mean, there are mandatory grounds, which are therefore
they're a bit archaic at the moment, aren't they? Because they're looking at updating the new grounds, aren't they?
They are, but broadly speaking, there's still, before or after reforms, there are mandatory grounds which the judge doesn't have any discretion on, and then discretionary grounds with the judge. And it's the discretionary grounds that can get very complicated and difficult. So the advice will always be to look to try and sort of on a mandatory ground under Section 8. So, for example, rent arrears. If your tenant has got into rent arrears, you can serve a Section 8 notice, and then you've got to prove at the moment that you've got 2 months arrears, the tenant's in 2 months arrears at the date you serve the notice and at the date of the hearing.
Right.
If you do that, the judge has no choice but to give a possession order. On the other hand, talking about rent arrears, if the tenant's not paid but has always been below 2 months arrears and persistently not paying, there are grounds 10 and 11, but the judge then has a discretion as to whether to grant the order, and often, the judge will find a reason for not granting the order or grant a conditional order, like a suspended possession order. So, that's how a Section 8 notice will work when it comes to rent arrears.
So, in effect, when, this is how the buy-to-let boom happened, wasn't it? It was as soon as the government introduced legislation,
the 88 Housing Act,
allow the landlord to get the property back under certain circumstances, the market exploded.
Well, that meant you had investment.
Absolutely. Now, let's talk about where we're going, because I think this is where a lot of the noise. What is the government looking to do? A little bit about why the government is trying to do it. And I know it's been pushed back a little bit in terms of we're probably not looking for these changes in the Renters Reform Bill until around about 2025.
And on that point, Ed, just because I think this is quite important for the people that watch and listen to this podcast. So obviously time frames. And we run lots of different government schemes. We're in lots of working groups, and obviously it's quite political. So we have a political change possibly maybe beginning of 2025. Yeah. So there is an argument. Obviously there's a 12-point plan on the Renters Reform Bill, and the real glaring worries for landlords or people is Section 21 and periodic tenancies and grounds and whatever. So the argument is, I'm going to throw this back at you before we go back to Paul. Is do you think that the Section 21 ban will happen before the next election?
So what an interesting point. Look, the Renters Reform Bill was never going to be an easy bill to introduce, because all of the areas, all the 10-point plan, 12-point plan, whatever you want to call it, are all interconnected. And the Renters Reform Bill was really an enabling act, more than anything else. So in other words, it gives permission or gives authority to the government of the day to introduce certain changes to the original Housing Act. Now, of course, when you talk about the banning of Section 21, which we're going to come on to, Paul, what's the future? It's not as simple as just saying, let's just remove Section 21. It's enshrined within the latest, in the 1988 Act, which means it's enshrined within the word fixed-term tenancy.
And it's given landlords confidence.
Yeah, so how do you actually remove it without creating absolute mayhem and everybody's tenancy agreement becomes null and void? You with me? And then landlords need to be educated what do they need to do.
There's periodic tenancies.
Absolutely.
So it's all disconnected.
But the one thing we do know, and this is probably one of the reasons why the whole thing is getting pushed back, because I think the government are now saying, well, actually, now we've announced all of this, actually, what's the best way of introducing it? Yeah. But what we do know is that the vast majority of the Renters Reform Bill, as it was constructed, had cross-party support.
Yes.
So whoever you happen to support or whoever's the government of the day, they don't want tenants evicted for no good reason. Yeah, and you are correct, Paul. You mentioned earlier there is a lack of housing in the UK. So yes, let's change everything to our heart's content, and then what? Where do we put all of these people? We've also got a migrant issue at the moment as well, which is clogging up a lot of the available housing.
You see the temporary accommodation, you see the hotels 100%. That are all booked up.
Yeah. So again, cross-party support for the changes in Section 21 and Section 8, cross-party support for allowing tenants to have pets, cross-party support for improving the green energy crisis, which is looming. We've all got, the government have got targets, in 2020, in 2030 and 2035 to hit. So I don't think you're going to see any fundamental changes to that renters reform. The highlights, what the art is going to be, is
how do you implement
it? And I think this has got to be step away from electioneering, because this is too big just to talk about, well, let's introduce it now and then we'll win the next election. I don't think that's how it works. So I think what you'll find is that the next 2 years will be a lot of talking. Housing will become a political priority, but I don't think you'll see this whole thing being revoked.
I think a priority, but not football.
So bringing that back, we're getting rid of Section 21. It's a big fear for landlords. We speak to them day in, day out. Yeah. The section we've now got 60% of our instructions are Section 20 and 40 Section 8. We've never ever had that since I started the business 23 years ago. Right? There is going to be an abolishment date, and my prediction is you will get landlords that might accelerate it and possibly panic. And we've got to really make sure there's no panic. You need a good court system. You need strengthened grounds, selling the property, moving back in. There's going to be more mandatory grounds. There's 17 at the moment. It could be 22, 23. We deal with the courts, okay? You need confidence in the court system. How would it work, Paul? When you abolish Section 21, what really needs to be put in place?
Okay, so the debate that we're going to have over the next 12 months leading up to it coming into force, the main ones that we've seen in the bill, centering around, as you said, Paul, the ground where the landlord wants to sell, the ground where the landlord wants to go back into the property, ground 1 and ground 1A, as we're going to have. Also on the rent arrears, the serious rent arrears, where a tenant has persistently failed to pay the rent and at a high level. So I think they're going to be the two main areas that where the Section 21 goes. The Section 8 will be.
But where does antisocial behaviour come in? Because this is a big point for landlords. At the moment, you use Section 21. At the moment, you use ground 12. And I've been quite opinionated on this because I speak to lots of landlords that have antisocial tenants. And at the moment, they use Section 21 to be able to get them out.
But the government have said, haven't they? They've recently gone. Gove, I think Michael Gove has turned around, and I think with a meeting with the National Residential Landlord Association, that antisocial behaviour is not acceptable, and they are looking at strengthening the grounds to deal with that. But I mean, we're getting into the detail, I think, and we could be here for hours. Let's just focus back. What does the Renters Reform Bill look to change with Section 21 and Section 20 and Section 8?
Okay, so there's some specifics that I mentioned there: Ground 1, Ground 8. But generally, and as far as trying to sort of calm any concerns or anything like that, my view is that what the main thrust of the Renters Reform Bill will be, once it comes into force, once it comes into legislation, is to move the focus away from end of tenancy and more towards the duration of the tenancy. So that what I think is going to be key is that the landlord, I'm not saying that there's hundreds of landlords doing this, but the temptation sometimes is to meet your tenant at the beginning of the tenancy, you sign the tenancy agreement, and to be honest, you don't see the tenant again until it gets to the end of it. You've got that Section 21 at the back. That, I think, is going to go. And I think what a landlord's going to have to do is have a much more, a better relationship, but a better relationship with their tenant. And as long as you do that, and you know that there are disrepair problems, they know that you're going to want to sell, or whatever the reasons that you want the property back, as long as you've got that relationship going and you can develop a good rapport, I think that the Renters Reform Bill is not going to cause too many problems. Yes, I think there are going to be issues for smaller landlords. There is a lot more paperwork, and you need to takes time to develop the relationship and keep in contact. So it's going to be difficult for people with one property, and I think there's going to be less landlords, but with bigger portfolios. I think that's going to happen, but. I think for whoever is up for the challenge, I think it's there. As long as you, keep in contact with the tenant. You can't rely upon the 21 anymore, and make sure that you know what they're doing, they know what you're doing, and I think you won't have to worry so much.
One thing that we haven't mentioned actually, which is part of the 12-point plan, and we introduced it during COVID when the notice period went to 6 months, is mediation. So mediation will form part of the court process. So you'll have to try and mediate. Look, you can't mediate with a tenant, Ed, if no one wants to talk to you.
Absolutely.
So it takes two to tango. So what I'm saying is you'll have to show that you've tried to mediate. Now, mediating does work. The problem we've got, so I'm being a bit cynical here, is the housing crisis that we have. And there's too many tenants that are just stringing it along because, one, they've been told by the council, or two, they've got nowhere else to go.
Absolutely, yeah.
Yeah, I mean, I think that the lack of housing is the issue, and that's not a private rented sector issue. That is that is a social.
And of course, then
sector.
you've got the cost of living crisis carrying on, where rents are going up 10%. I think it's in 2,500 in central London now.
I mean, the average rent in London's about 2,100. Yeah, it's a lot of money. It's a lot of money.
So it's although let's again be a bit positive here. In COVID, in the pandemic, there wasn't the crisis everyone foresaw because landlords did talk to their tenants
But also,
that's key.
That is key.
They did talk and they did some great work. But the positive for the landlords that are in the market and are looking at this long term, because buy-to-let is long term, and as I've said this many times before, I even saw a Facebook post with a landlord that I know. They're getting a pool of better tenants to pick from, more tenants to pick from. There's less void periods than ever before.
Yeah.
And it's really stressful to tenants because they're fighting over to try and get into property because there's a real lack of stock out there. So actually, for landlords, you are getting a pool of better tenants than you've had before.
You're watching The Property Cast, powered by the award-winning Total Landlord Insurance.
Do you think, Paul, that one of the issues is that landlords don't really understand how to issue the current notices? I mean, we've seen quite an increase in numbers of inquiries coming through to Landlord Action. In fact, dramatic increases over the last. Is that because landlords don't really know what they're supposed to be doing when they're coming to issuing these notices, or that when they are doing it, it's going wrong for them and therefore they're coming to you for help?
Yep, I think that's absolutely right. I mean, I have to say it's not just landlords, it's often agents as well. It's because there are so many hurdles to get over. It's not that difficult to get it wrong. So, you serve a notice. What we do at Landlord Action is we try to give a Rolls-Royce service. Absolutely get that notice right at the beginning. Look at every single possible concern that the tenant might raise, whether it's the gas safety, whether it's the deposit regulations, service. That's a big key area. We can't prove service. Make sure that we've got everything in order, and only then serve the notice. If you get that notice right, the next stage is, you're in the hands of the court, but
I think the big worry going forward when Section 21 does go in a couple of years is that landlords will have to start using Section 8s and understand all the grounds. And then, look, I issued my first possession claim in 1991 when I worked in a firm of solicitors. Right, I would not recommend any landlord to try and issue a Section 8 claim going forward in the new world, because one slightest mistake,
you go back to the beginning.
Beginning, and it's really costly, especially when you've got court delays that are happening. Is that right, Paul?
Absolutely. And obviously the point about Section 8 is, you do have to give a reason, therefore the tenant's going to have the opportunity
and you
to
go
put forward.
before the judge as well in a hearing.
Absolutely. The tenant has the right to put forward their defence. They do with a 21, but it's just not as it's not really designed for that. Section 8 is designed to come to court, have a hearing, and for the tenant to have their say. It is important to get that notice right and to be supported by someone that's got the experience and the knowledge to how it works in the court.
Yeah. Of course, the Renters Reform Bill is going to be the biggest shake-up in the housing, the private rented sector for 25 years. So this is one of the reasons why we're talking about these things in our property casts going forward, is to try and prepare the landlord.
Who are very adaptable.
Absolutely, and the letting agent, because remember, if you use a letting agent, you're still responsible, Mr. Landlord, Mrs. Landlord, if the letting agent gets it wrong. So it's making sure you pick, if you're using a letting agent, the right letting agent. And I think your point there is don't get the process wrong currently, because you go back to the beginning and it could have a massive impact on how much on the rental.
And it's very hard to collect your rent arrears from a tenant.
Absolutely, because once you get an eviction order, you still got to get a money order.
Trace them.
They're gone.
They're gone. A lot of tenants don't have any assets.
That's the problem.
Yeah.
Paul, thank you. It's a very deep subject, and it is going to be a subject that we are going to keep returning to, I'm sure, as more information comes out. But I think you've given some good tips there, and we've got a lot more information for you on all of our websites.
Some really good guides as well.
So I'm going to throw you to Total Landlord Knowledge Centre, and of course join Landlord Zone for further information. The links are on the screen and in the information below.
You're watching The Property Cast, powered by the award-winning Total Landlord Insurance.
Let's have a bit of fun, as we always do at the end of our podcast. You're smiling there, Paul, because you don't know what's about to happen and what's coming down the line. But we're going to give you £20,000. That's not because you're a nice guy.
We're pretending to give you.
You are a very nice guy.
Not really giving me 20.
That very clear. Read the T's and C's, Paul.
And
I'm thinking about where I'm going on holiday.
You are allowed to use that £20,000 not to go on holiday, to improve a rental property that you happen to own in Little Snoring on the Marsh. What would you do with that £20,000? What changes would you make to your property, and why?
Well, I am a solicitor, and I am all about getting the procedures
We love
right.
solicitors.
And honestly, I would say with the renters reform coming up, if you want to have your tenants working for you, the tenancies, that rent coming in, and there not being at least problems as possible, I would advise having some support to help you get the paperwork right. Some sort of administrative support. I know that's not what you want to hear. You're thinking about the property itself, but I think honestly,
I'm up for any.
Honestly, I really believe that these aren't. we've talked about it being a deep issue and it's a historical thing as well, but it isn't rocket science. It really isn't. You can do this, but you just need to be on top of the paperwork. If you've got someone supporting you, it will be money.
You're talking
well
about managing
invested.
agent, are you?
Managing agent, or someone,
An administrator.
an administrator
Yeah.
of some kind that can help you make sure things. Because obviously the managing agent is just an agent. They're doing it on your behalf.
Yeah.
So it's your responsibility. Get it right. That does mean time, it does mean effort, but getting someone to support you
I think,
that.
do you know what?
The reality is you'll get some change out of 20 grand, Ed, to be honest.
Yeah, I mean, well, if they use landlord action, I would generally say what a great point you make there, Paul, because ultimately, I think part of the issue in the sector is that people don't see themselves running a business, and ultimately, I think landlords are suppliers of accommodation. Yeah. Now I know the government don't necessarily look at landlords as business people, because a landlord can be a landlord for many reasons.
But it is a profession.
Grandparents die or divorce, and you've got
Accidental.
2 houses and you let one out, or you're in transit. So you know where you want to move, so you sell your property and then you rent it out whilst you're buying your new property. But ultimately, the way the government has been working over the last 20 years, and not just the Tories, but in Labour and going forward, is there will be more and more changes coming down the line. We're only picking up on a small bit with the Section 21 banning, but if you don't know what you are doing, now the fines, now the restrictions on being a landlord are getting more and more tougher. So I agree. I think that is a great idea. Yeah. Research, spending money on research, making sure that you've got the right support, making sure that you understand what you're doing, and I think that's great.
Just to emphasise that point.
HF assist. There you go. There's
Yes,
another.
you just have it is the case that people aren't able to go into the social housing sector. They are in the private rented sector. They are more vulnerable.
Yeah.
You need help with that. And I think that's so important.
Absolutely.
Understanding the needs of your tenants will make the tenancy go much better.
And £100 also to join the NRLA.
Yeah, it's cheaper actually. It's £85.
£85, even better. You saved me even more money, and I was just sitting there, just use the word
advice
Champlainer.
line's really
So, but yeah, Paul. So thank you for
Thanks
that.
for coming in, Paul.
Lovely, really. We'll
Pleasure.
pick up again as things move forward. I'd love to invite you back again and give us the up to date. So that's our property cast for this month. Paul, thank you
Pleasure, Ed.
for coming in again, and Mr. Sowerbutts, thank you once more. And I'm looking forward to speaking to you next time.
You've been watching the Property Cast, powered by the award-winning Total Landlord Insurance. For more, please visit totallandlordinsurance.co.uk.